Okay, are we live? All right, great. Dean Cockery, members of the Board of Trustees that are here with us, Board of Advisors, Professor Ochoa, ladies and gentlemen, good afternoon and welcome. I'm very pleased that you're here with us for our IP lecture series. My name is Daryl Lim. I'm the Director for the Center for Intellectual Property, Information and Privacy Law here at the John Marshall Law School. And if there's one thing I want you to know today, it's that IP lives here. 1 in 3 students that come to John Marshall indicate an interest in IP. We have strong partnerships with our IP institutions here in this country, with alums, with employers, and we are just thrilled to be part of a community that lives and breathes intellectual property. And we're also very proud of the fact that we have strong partnerships with the school. And because of that, I'm going to leave it to Dean Cockery to speak more about the center and its history and its relationship with the school over the years. But one thing that I want to leave with you is that we're always trying to do today what others do tomorrow. And so we're very happy to introduce streaming of our events, and this is as great an event as any to start off with. So we're very pleased that Professor Ochoa is here to start off this streaming series this academic year. And without further ado, please join me in welcoming Dean John Cockery.
Well, thank you so much, Daryl. I'm very pleased here to be able to also welcome you on behalf of law school for the presentation today to our talk on the subject matter of copyright. And as you can see, I think it's going to be very interesting. And I'm told that it will cover such subjects as cheerleading uniforms, the Batmobile, and a chicken sandwich. So I'm very much looking forward to seeing where we're going to go with that. Our speaker will be introduced later, but I thought initially I'll just tell you a little bit about John Marshall and our IP program. We've had a long history doing IP, over 80 years, I think it is, and we have a variety of doctrinal and clinical courses which I think compare with the best in the country, and we've been ranked by U.S. News and IP for the last, I guess, 15 to 20 years, so we're very pleased with that. We have a lot of events involving IP. Since last October, we've had 15 events, and we plan to have 9 more this coming semester. So, for these events, we seek speakers from around the country, across the world, from the judiciary, the PTO, Copyright Office, FTC, trade representatives, and all other areas where we might get speakers who really would have something to say. One of our goals is we want to be able to shape and define discussion and debate at the national level about really important IP and related issues. And we want to make the next generation part of our discussion, so we're very interested in reaching out to them. And speaking of the next generation, our students, we think are great. The USPTO has accepted them into its program that allows JD and LLM students to prosecute patents and trademarks, something that the PTO has allowed offered to very few schools, and we're very grateful for that. Students have attended all of our IP events, and we're going to create some new ones specifically for our students. We have a wonderful alumni, and our alumni in the city of Chicago are part of the fabric of IP law here. We are in constant communication with them. They teach our adjunct courses. They really add expertise and experience and vitality to our adjunct courses, and we're so proud to have such a base of knowledgeable and terrific IP adjuncts for us, and very grateful for all the help that they give us. We'll be at IPLA in DC this month, and we also, in the last few months, held a reception at INTA for our alums. As far as scholarship, our people, our faculty publish in leading IP journals, Cambridge University Press, Oxford University Press, and mainstream media. And we provide comments to government agencies, FTC, and antitrust agencies for guidelines, about guidelines and proposed new rules and regulations. We are already on Facebook and LinkedIn and Twitter. Go tell them that's good. And we're starting streaming these events. We think it would be a good idea. We hope it will increase our reach, and we think we're going to be successful at it. And so this is the first of our experiments in that area. We have an advisory board we're just absolutely thrilled about. Don Dunner, who is the chair of our advisory board. Many of you may know Don Dunner is an extremely well-known practitioner in IP, prominent attorney in D.C. He's with the firm of Finnegan, Henderson, Faribault, Garrett, and Dunner. That was a commercial. So. As you know, Don was the founder of that firm and actually one of the movers and shakers in the development of our present-day litigation system. So that's a few words about what we're doing. We very much, as Daryl said, value IP instruction. We look forward to continuing that. And I didn't mention it, but we have significant IP connections with China. We have a Chinese Intellectual Property Resource Center here at the law school, which is supported by law firms in China and other generous donors. So it's a very big issue, a very big love and interest that we have here at John Marshall Law School. At this point, it is my great pleasure to call upon my colleague Bill McGrath to introduce our speaker for the day. Bill?
Thank you, John. Thank you, and welcome to all of you who are here, and welcome to all of you who are in distant places and have tuned in on our live stream. So we're happy to have you. Just a few logistics. If you will all remember to silence your phones for now. And also, Professor Ochoa will speak for roughly 40 minutes, and then we're hoping to have 15 or 20 minutes of Q&A, including, for those of you who are listening by live stream, you can type in your questions and we'll try to answer those as they come in, or after the talk as well. So I would like to introduce, we have the great honor of having with us today Professor Tyler Ochoa, who is at Santa Clara University Law School. Professor Ochoa got his JD at Stanford, where he was in the Order of the Coif. After law school, he was a clerk in the Ninth Circuit, and then he went into private practice at Brown and Bain, and then he went into academia. Professor Ochoa is best known for his work in the copyright area and the right of publicity area. I would call Professor Ochoa a copyright lawyer's copyright lawyer. His knowledge of copyright law is so in-depth. He is a co-author of one of the leading copyright law treatises, or textbooks, I should say. He's worked a lot on issues of copyright duration and copyright in the public domain. He often, in his writing, looks very deeply into the kind of the historical side of copyright. He's one of the few people around that has really an in-depth knowledge of the 1909 Copyright Act, for which he should be duly proud. But lest you think he's mired in the past, one of his recent articles is entitled, "Who Owns an Avatar? Copyright, Creativity, and Virtual Worlds." So he covers things from 1909 Act and all the way on up to the current times. All that, however, pales in comparison to probably his most significant achievement, which is that he is a two-time Jeopardy champ. Not to mention that his sister is an astronaut, so he's got that going for him as well. So we've asked Professor Ochoa to come and educate us today about some of the wild things that are going on in the world of copyright in terms of what is copyrightable anymore. So, Tyler?
Thank you very much. It's a great pleasure to be here. I always enjoy coming back to Chicago, one of my favorite cities. So I'd like to thank Bill, Professor McGrath, and Professor Lim for inviting me to come and give this talk today. So when we were talking about a topic that we wanted to address, it was suggested that I talk about copyrightable subject matter. And in one sense, you might think, well, that's going to be a short talk because the general principles of copyright are very easily stated in just a few minutes. But as I think the next 50 minutes or so will show, the application of those principles to real-world problems turns out to be significantly complicated and involves all of the things that have been mentioned in the title and many more. And these are all cases that were decided within the last 2 years. So there's a lot going on in copyright that involves some of the fundamental principles as to what's protected. So before we get into those cases, it's probably a good idea to remind ourselves of what those fundamental principles are. So we can start with Section 102 of the Copyright Act, which says simply that copyright protection subsists in original works of authorship that are fixed in any tangible medium of expression. So that really sets forth just two principles for copyright protection. Your work has to be original, and it has to be fixed in a tangible medium. Fixed simply requires that it's recorded in some permanent form. Originality is not defined in the Act itself, but has been defined in Supreme Court case law. The leading case on originality, Feist Publications versus Rural Telephone Service Company, involves decidedly old media, the white pages of the telephone phone book. But the U.S. Supreme Court defines originality and says original means only that the work was independently created by the author, as opposed to copied from some other work, and that it possesses at least some minimal degree of creativity. So there's our definition of originality: independent creation plus a minimal degree of creativity. And the Supreme Court held that the telephone white pages did not meet that standard because everything in the white pages were facts, name, address, and phone number. Facts are not protected by copyright because they're not original to the author. They weren't created by the phone company. The facts already existed. The phone company could have a copyright in an original selection and arrangement of facts, but the court held that selecting all of your subscribers and arranging them in alphabetical order by last name did not show even a minimal degree of creativity, therefore no protection. Section 102A goes on to list 8 categories of works of authorship. So this might be thought to be a third requirement. You should probably fall within one of these 8 categories. Statute actually says it includes the following categories, so in theory we're not limited to these things. But I've never seen a reported case that involved something that wasn't on this list. Partly because they're defined very broadly. All of these categories are defined very broadly. They overlap to some extent. One of the categories, however, has a significant narrowing in the definition, and that's pictorial, graphic, and sculptural works. So if we go to Section 101, where all the definitions are, we see our definition of a pictorial, graphic, and sculptural work includes the following limitation: that the design of a useful article shall be considered such a work only to the extent that it incorporates pictorial, graphic, or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. So the idea here is that we don't want useful articles to be protected by copyright. Useful articles should go to the patent system. They're going to have to meet the higher standards of patent law, that they be useful, novel, and non-obvious. And they will only be protected for a much more limited period of time, only for 20 years. So only the aesthetic aspects of a useful article that can be separated from the utilitarian function, only the aesthetic aspects of a useful article can be protected by copyright. And Section 101 also gives us a definition of what a useful article is. Okay. So we're going to be taking a look at originality. We're going to be taking a look at useful articles. And finally, we're going to be taking a look at Section 102B. Section 102B is a significant limitation on the scope of copyright protection. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in a work. This is a principle that goes back in Supreme Court case law all the way to the 19th century, and it's been codified in Section 102B of the 1976 Act. And again, the principle is certain things just shouldn't be protected. Ideas, concepts, principles, and discoveries, those things should be in the public domain so that everybody can debate them, talk about them, incorporate them into our new works. So ideas, concepts, principles, and discoveries simply not protected by copyright, in the same way that they would not be protected by patent law. Procedures, processes, systems, methods of operation, those are things that could be protected by patent law. But again, we don't want to protect them by copyright. We want them to go to the patent system where they have to meet the higher standards of patent law and be protected for a shorter period of time. So with that introduction to the basic principles, let's take a look at a bunch of recent cases that have involved the question of what is copyrightable subject matter. It's important to remember that this may come up at a couple of different stages of a litigation. It could come up at the Copyright Office when you seek to register your work. Copyright Office will just take a quick look at it and say, do we think this fits within the definition of copyrightable subject matter? They don't really examine it the way that patent law does. They don't compare your work to prior works in the public domain. They just ask, does it fit within one of our 8 categories and general principles of copyright? If so, you get your copyright registration. We could also ask that in the first element of a copyright infringement action, you have to prove ownership of a valid copyright. Well, so we could ask, do you have a valid copyright? But at either of these stages, registration or ownership, it's pretty easy to meet the standard. All we're looking for is there some original expression in your work which meets the standard of copyright? If so, we're going to get a registration, and that's going to be easy. The harder part comes when we get to the infringement stage. And at the infringement stage, we have to ask whether what the defendant copied was protected expression or not. Right? And so here, it's much more limited inquiry. Not, did you come up with anything that was original expression, but did the protectable parts of your work, was that copied by the defendant, or did the defendant instead copy things the defendant is allowed to copy? Ideas, procedures, etc. So if the defendant only copied things that are not protected by copyright, there will be no infringement, even though the plaintiff might have a valid copyright in other aspects of his or her work. So let's start with Home Legend versus Mannington Mills. This is an action for a declaratory judgment of non-infringement. So Mannington Mills is the copyright owner, Home Legend is the alleged infringer, and this is the work that was involved in the case. And you're probably looking at that and thinking, dude, that looks like a hardwood floor. And that's kind of the point, is that it looks like a hardwood floor. It's actually a digital photograph of a hardwood floor. Why would Mannington Mills want to protect a digital photograph of a hardwood floor? Mannington Mills sells a laminate product, a wood laminate product, that consists of a layer of particle board, which is cheap and easy to manufacture. They've got the digital photograph of the hardwood floor on top of that, and then they have a layer of clear plastic or acrylic on top of that for durability. So what they're selling is a wood laminate product that looks like a hardwood floor, but is much cheaper and easier to manufacture and easier to maintain. Right? And they are alleging that Home Legend, a competitor in the flooring business, has copied their digital photograph of a hardwood floor. Now, surely, just taking a photograph of a hardwood floor isn't going to be eligible for copyright protection, even though most photographs have some minimal degree of creativity. What if you really added to the floor if all you did was took a picture of the floor? But that's not quite what Mannington Mills did, and the Eighth Circuit rules that the digital photo is sufficiently original to be protected by copyright. Why? Because of the process that Mannington Mills used to make it. They first commented that wood grain occurs naturally, so that if you simply scanned a raw wood plank, took a digital photo of that, that likely would not be copyrightable. But that's not what Mannington's people did. They did considerably more. They took a whole bunch of raw wood planks. They used hand tools to add gouges, dents, nail holes, ripples, chatter marks, and other imperfections to various planks. They then used rags, sponges, and brushes to apply various colors of stains to the planks. They selected and arranged combinations of planks that they thought would go well together. They chose 30 planks to photograph with a high-resolution digital scanner. Then they digitally retouched the resulting scans and finally selected 15 plank images to merge into the final design. Now, that's a lot of time, labor, and effort. One thing we know from the Feist case is that time, labor, and effort by itself does not create a copyrightable work. The Supreme Court in the Feist case said that sweat of the brow was not a basis for copyright protection. It had to be originality. It had to be a minimal degree of creativity. But, of course, this process has resulted in a minimal degree of creativity. Mannington was making creative choices in deciding how to alter the raw wood planks that they had selected, and then selecting and arranging particular ones to put together, retouching them, selecting and arranging, and putting it into the final product. And so the Eighth Circuit says, yes, this is sufficiently original to be protected by copyright. But how about the fact that our wood laminate flooring product is also a useful article? We have to deal with the limitation on useful articles. Here, the Eighth Circuit says our digital photo is not rendered ineligible as the design of a useful article because the image of the floor is physically and conceptually separate from the wood laminate floor to which it is applied. How do we know that it's separable? Well, first of all, Mannington sells laminate floors with lots of different designs. You don't have to get this hardwood floor. They've got several other hardwood floors to choose from. You can get other pictures sandwiched in between your particle board and your acrylic topping in your laminate floor. If you want your floor to look like something different, like tile or marble, you can get a whole bunch of different pictures. So we know that the picture can be separated from the wood floor. And as an image, it could be used as wallpaper. It could be printed, framed, and hung on the wall as art. So it says there is separability. Therefore, the useful article limitation doesn't prevent it from being eligible for copyright. And finally, the digital photo is not ineligible because of Section 102B. Mannington is not claiming copyright in a procedure, process, system, or method of operation. They are instead claiming copyright in the result of such a process, which displays minimal but sufficient originality. Our next case involves yoga. Bikram's Yoga College of India versus Elation Yoga. The Bikram, whose name appears in the title, Bikram's Yoga College, his name is Bikram Chowdhury. He is the self-proclaimed yoga master to the stars, claims a lot of the credit. He came to the United States in the 1970s, claims a lot of the credit for making yoga popular in the United States. And he's claiming a copyright in a particular sequence of yoga poses that he espouses in a number of different books. 26 different yoga poses that have to be performed in this precise order. 26 yoga poses and 2 breathing exercises. Here are the poses. This is the order in which they are to be performed. And he claims copyright in that sequence. Now, we're thinking, okay, yoga can't possibly be original to you. Yoga is thousands of years old. It's been practiced in India for thousands of years. So surely you can't claim that this is original to you. And he says, well, no, I'm not claiming that any of these poses are original. They're not. Right? But I am claiming that this sequence is original, that nobody else has selected these precise 26 poses and put them into this precise order. That, he claims, is a piece of choreography. Right? Choreography is a series of body movements that can be synced to music. Pantomime is a series of body movements without music. Both pantomime and choreography are listed in Section 102 of the Copyright Act as eligible works. And he says his sequence of body movements should be considered eligible as a copyrighted work as well. Well, when he went to register with this with the Copyright Office said, no, we don't think that this is a pantomime or a choreographic work. Why not? In the legislative history suggests that folk dances and social steps are not protected by copyright in choreography. What's the difference between folk dances and social steps, which are not protected, and choreography, which is protected? According to the Copyright Office, it's the fact that pantomime and choreography are intended to be performed for an audience. And if instead it's an audience participation where people are intended to participate in the activity, then it's a sport or an athletic event, and that's not copyrightable. So sequence of body movements intended to be performed by an audience, copyrightable according to the Copyright Office. Sequence of body movements intended to be performed by the audience as a participatory activity, not copyrightable according to the Copyright Office. But of course, if you tried to register and you were turned down, you can still sue for copyright infringement, and the court will get to decide whether that's the case or not. The Ninth Circuit decides to avoid that altogether. We're going to avoid the consideration of what the definition of a choreographic work is. Instead, they say that the sequence is ineligible under Section 102B. This is an idea or a process or a system that is designed to improve health. Why? Because all throughout all of his materials, Bikram claims physical health benefits for using the sequence. And he says you have to do it in this exact order, or you don't get the spiritual and physical benefits from doing yoga. You have to do it in this exact order. You have to do it in a room that's heated to 105 degrees. He's popularized hot yoga, right? So it's got to be 105 degrees. You have to do it in this order. And everything in the material stresses the importance of performing the sequence in this order. And the court says, well, we're going to take you at your word. If you're going to tell us that doing the sequence in this order provides certain health benefits, that makes it a process or a system that is therefore ineligible for copyright protection. Conclusion, the sequence is not a copyrightable choreographic work, not because of the definition of choreography. Again, the Ninth Circuit decided not to review that, but simply because all works are subject to Section 102B. Our next case is Lorenzana versus South American Restaurants Corporation. The South American Restaurants is the franchisee of Arby's that operates in Puerto Rico. So they're an Arby's franchisee. Lorenzana is one of their employees, and he claims that his employer has stolen and benefited from using his copyrightable work, and this is what he claims is a copyrightable work. And once again, you're thinking, dude, that's a chicken sandwich. And it is indeed a chicken sandwich. But he says he came up with the recipe for this chicken sandwich, and that he came up with the name Pechu Sandwich, and that his employer put it on the menu to great success, and that they owe him some compensation for using his copyrighted work. I'm amazed that this got to the appellate level. Obviously, they lost in the District of Puerto Rico. Appeals from Puerto Rico go to the First Circuit in Boston. And the First Circuit disposes of this one very quickly. A chicken sandwich is not eligible for copyright protection. It's not within any of the 8 categories listed in Section 102. And indeed, you would be hard-pressed to say which of the categories does this fit in. The best you could possibly do is maybe it's a sculptural work. Is it fixed in a tangible medium? Yes, very briefly until it's eaten. But once again, mere recipes or a list of ingredients is functional under Section 102B. A recipe, a list of ingredients, and how to combine them in particular order, that is a procedure, process, system, or method of operation. And that's ineligible for copyright protection under 102B. If you want to protect your recipe, you got to go and get a patent. And you're going to have to meet the higher standards of patent law. You're going to have to show it's useful, novel, and non-obvious. And while no one doubts the utility of a chicken sandwich, novelty and non-obvious would be a pretty hard standard for this chicken sandwich to meet. Right? He also claims copyright protection in the name, Pechu Sandwich. But we know that copyright does not extend to words and short phrases, such as names, titles, and slogans. That's actually a regulation that the Copyright Office has promulgated. So why do we not protect copyright in words and short phrases? Because words and short phrases aren't works. They're the building blocks from which works are created. You take words and phrases and you select and arrange them into a literary work, something larger. So size is an important limitation on copyright protection. the building blocks that we use to create copyrighted works are not protected by copyright. You have to select and arrange things into something larger than a very short phrase. So names, titles, and slogans, generally not protected by copyright, and not protected here. Now we can get to the cheerleading uniforms. Varsity Brands versus Star Athletica was the name of this case in the Sixth Circuit. The Supreme Court did grant cert earlier this year. Oral argument's going to be heard on October 31st, so it's very timely. We've just got a few weeks before the Supreme Court will hear oral argument. In the Supreme Court, of course, the petitioner is listed first. So in the Supreme Court, the name will be Star Athletica versus Varsity Brands. But this case is upcoming. So why did the Supreme Court grant cert? Here was the question presented to the Supreme Court. What is the appropriate test to determine when a feature of a useful article is protected under Section 101? Now we know what the Copyright Act says. We looked at that definition earlier. We'll get to the uniforms in a minute. Well, let's go ahead and take a look at the cheerleading uniforms that are at issue here. Varsity Brands creates a bunch of different cheerleading uniforms with different designs involving color blocks and various chevrons with stripes. Here are two of the designs that they've registered in the Copyright Office. Here are two other of the designs that they've registered in the Copyright Office. And they claim that Star Athletica is copying their material. Right? Well, going back to this, we know what our definitions are, that the design of a useful article is considered a pictorial, graphic, and sculptural work, only if and only to the extent that it has pictorial, graphic, or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. So we can go back to those pictures and ask, well, what are the features that are separable from the utilitarian aspects of the article? And the difficulty here is that the circuit courts cannot agree on a single verbal formulation that defines what it means to be separable. They all focus on the legislative history. The legislative history says it can be physically or conceptually separable. And they're asking, what does conceptual separability mean? And then the Sixth Circuit said that they've come up with 9 different tests that have been advocated either in various court opinions or by treatises and commentators on copyright. 9 different tests for deciding what is separable. I think that's a bit of an exaggeration. You look at some of these verbal formulations, they're pretty much the same as some of the other verbal formulations. But other circuits have identified at least 6 different tests that have been used in deciding whether something is separable. One of the leading tests was proposed by Professor Denicola in a law review article and was adopted by 3 different circuits. And it has to do with the design process, the process by which a design was made. That if the design was significantly influenced by functional features, then it is ineligible for copyright protection. If the design was made without any consideration as to functional influences, then it could be eligible for copyright. That makes a certain amount of sense. It is inconsistent with the legislative history, which says that the design process really shouldn't be a consideration in deciding these things. Professor Nimmer has proposed a different test where he asks, well, would this be marketable if it was not part of a utilitarian article? Right? Is anybody going to buy stripes and chevrons if they don't perform part of the cheerleading uniform? We might think that the answer might be no. On the other hand, lots of abstract art consists of nothing more than color blocks and stripes and angles. So maybe somebody would buy this as a work of art if it wasn't a cheerleading uniform, if it wasn't a dress. A little hard to tell there. We've had a test to be considered whether or not you could look at the design and see it as a work of art without thinking of a useful article. I think that test would be very difficult to satisfy here. The Sixth Circuit came up with something radical. It read the plain language of the statute. Right? And first asked, well, is the registered work a pictorial, graphic, and sculptural work? Because this limitation only applies to pictorial, graphic, and sculptural works. And what was registered was a drawing, and a drawing is definitely a pictorial or graphic work, so we meet step 1, no difficulty there. Now, there's another limitation in section 113B, which suggests that just because you've registered a drawing does not give you an exclusive right to manufacture the useful article that's depicted in that drawing. So again, we'd have to have separable features in order to have some sort of exclusive right. Okay. Second, is the work the design of a useful article? Yes, cheerleading uniforms are useful. All sorts of fashion designs are considered useful. Clothing is useful because it covers the body. Right. Third, what are the utilitarian aspects of the article? Here we're getting sort of to the nub of what the statute is asking about. And the Sixth Circuit said, well, we think a cheerleading uniform should cover the body, should wick away moisture, and be able to withstand the rigors of athletic movement. That those are the utilitarian aspects. The district court had said, I think this is a useful article because you can't have a cheerleading uniform without identifying who you're cheering for. Right? And the Sixth Circuit looks at that and says, well, we don't think that meets the definition of a useful article. Because a useful article has to be useful for reasons other than just portraying the appearance of something or conveying information. Right? If it's useful just because it tells you what something looks like, that's not a useful article. If it's useful because it conveys information, that's not a useful article. So maps are very useful, right? But the utility in a map lies in conveying information. That doesn't make it a useful article within the meaning of the statute. The utility has to be something other than conveying information. We think the stripes and chevrons that tell you which team you're cheering for convey information, and therefore that is not a utilitarian aspect of the article. Covering the body, withstanding the rigors of athletic movement, that's what's utilitarian. Step 4, can the viewer identify any features that are separable from the utilitarian aspects? Yes, the stripes, the chevrons, the color blocks are separable because you don't need those in order to fulfill your utilitarian aspects. And can those features exist independently of the utilitarian aspects of the article? The court says yes. You can have stripes, chevrons, color blocks. Just because they're part of the design of this cheerleading uniform doesn't mean that they're not separable. Okay. That's a reasonable conclusion. I was kind of surprised that the Supreme Court granted cert because I think the Sixth Circuit essentially got it right. I might disagree with the Sixth Circuit if those stripes and chevrons were actually part of the way that the uniform was put together, the way that the uniform was sewn together. Then I might think that that was functional. But if it's just printed onto the uniform, which is otherwise sewn together in an ordinary way, then I would agree with the Sixth Circuit that this is separable. Fabric patterns of all types have been registered in the Copyright Office because they're considered separable from the way that the fabric is put together into clothing. But of course, the reason the Supreme Court takes the case is because we've got all of these different tests floating out there. And we're hoping that the Supreme Court will provide some guidance. Maybe they'll select one of the tests and say, this is the test that you should be using. At the very least, we hope that they do something other than totality of the circumstances, which isn't going to provide some guidance. But right now, the circuit courts have adopted a bunch of different tests that are really split. So it would be very helpful if the Supreme Court provides some guidance on this issue. Our next case, Direct Technologies versus Electronic Arts. Very recent. This was only decided about a month ago by the Ninth Circuit. Electronic Arts, of course, is a video game manufacturer. This case involves a derivative work that is also a useful article. So it's helpful to remind ourselves of the rules concerning derivative works. Here's the definition of a derivative work: a work based upon one or more pre-existing works, such as, it gives a whole bunch of examples, including a translation or a motion picture version, or any other form in which a work may be recast, transformed, or adapted. And yet the copyright in a derivative work is limited by Section 103B. The copyright in a derivative work extends only to the material contributed by the author of the derivative work, as distinguished from the pre-existing material employed in the work, and does not imply any exclusive right in the pre-existing material. So if you've got pre-existing material and you make a derivative work, you only get a copyright in what's new and what you've added. You don't get a copyright in anything in the pre-existing work. Well, here is the alleged pre-existing work that Electronic Arts created. Now, if you are a regular player of Electronic Arts video game The Sims, you know what this is. This icon is called Plumbob, and it is used in The Sims to indicate a character that you have selected or are currently controlling, and it actually is animated. It rotates above the head of your character. Okay. Now, if you tried to register this in the Copyright Office, I have serious doubts as to whether you'd be successful. Right? It's a 12-sided polygon-type form. I just don't think, if you tried to register the shape by itself, I guarantee you the Copyright Office would say no. Geometric shapes by themselves are not copyrightable. Okay? If you add the color and the lighting and the shading and you add the animation in, okay, maybe that's enough minimal creativity to get it past the Copyright Office. They might say that's registrable. But of course, that's not what Electronic Arts registered. Electronic Arts registered an entire video game, of which this is a very tiny part. Right? Clearly, there's plenty of original expression in the video game as a whole, so there's no problem getting the video game registered. The question then becomes, is this protectable expression part of the video game? Again, I have my doubts, but that's not the issue in the case. The issue in the case involves the derivative work of this portion of the game, right? Because Electronic Arts thinks, you know, we should capitalize on the popularity of The Sims. We should try some sort of merchandising. How do we merchandise Plumbob, right? And they came up with the idea, well, you know, maybe we could make a USB stick so that fans of The Sims would love to have a USB stick that looks like their jeweled Plumbob. So they contract that out. They find a contractor, Direct Technologies, and Direct Technologies comes up with a design of a USB stick based on Plumbob. And here's what it looks like when it's manufactured. Right? So it's green. It's a 12-sided polygon, but you can pull part of it out that becomes a USB stick. Right? Surely that is a useful article. A USB stick is a useful article. The functional aspects of the useful article, the interface, can't be protected by copyright. Question is there any originality in the design of the USB stick that didn't already exist in Electronic Arts' underlying work, pre-existing work? And the Ninth Circuit looks at this. First of all, there was a problem because they had gotten an assignment of rights from Direct Technologies. But in a previous opinion, the Ninth Circuit already held that the assignment could be invalid and unenforceable because of fraud in the inducement. What happened? They got the design from Direct Technologies. They led Direct Technologies to believe that they were going to be ordering copies of the USB stick from them and had them sign an agreement assigning the rights in exchange for this manufacturing contract. And then they subcontracted the manufacturing contract to somebody in China who promised to make the USB sticks for 50 cents less. So Direct Technologies feels like it was defrauded. You misled us. And if they can prove that, then the assignment of rights would be invalid, and they might have some rights in the derivative work. And they're only claiming joint authorship rights in the derivative work, not sole authorship rights. As to originality, the Ninth Circuit said there's a genuine issue of material fact as to whether or not the design was functional or utilitarian. Is there anything about this design that you could claim was not functional? Pretty dubious here, and we'll come back to that. But the Ninth Circuit says enough to get past summary judgment. We're going to let a jury decide. And there's a genuine issue as to whether or not it was sufficiently original to warrant copyright protection. Now, in terms of the functionality, the reason the Ninth Circuit says this might be non-functional or it might not be utilitarian, or more precisely, that it could be separable from the utilitarian aspects of the article, is because they came up with a whole range of alternatives. Right? Lots of different ways to turn Plumbob into a USB stick. And they selected this particular one. And so the court says, well, that makes it clear to us, or at least there's enough evidence which would suggest that this design was not driven by purely utilitarian concerns, that there were other ways to turn this into a USB stick. And they didn't pick this one just because the USB stick worked better. but they picked this one because they thought it looked cooler. Aesthetic aspect versus a functional one. Now, what's original about this? Our 12-sided polygon already existed. The only thing they can point to, and does this thing have a laser pointer on it? There we go. The only thing they can point to is, well, we made it cut away from the design in a cool-looking, futuristic way. And the Ninth Circuit said, oh, that's sufficiently original. I think the Ninth Circuit is really stretching here. And they're really stretching because they think Electronic Arts really did defraud direct technologies, or at least that there's a genuine issue about that. And if so, they might be entitled to some extra money here. But I think it's a real stretch to say, ooh, making it cut away in that manner should be sufficiently original to be protected by copyright.
Your battery. Sorry about that. Thank you.
Replacing the batteries here, which is, of course, the utilitarian aspect of useful art. So don't claim any protection for that.
Okay. Sorry about that.
Just I did promise the Batmobile. We can talk about it now. DC Comics versus Towel. So I'm sure you're familiar with the Batman comic books. They've been around since 1941. And during that entire period of time, they have featured the Batmobile. Batman drives around in the Batmobile. It's a fictional high-tech automobile with bat-like features and high-tech weaponry. Now, the design of the Batmobile has actually varied quite a bit over time. In the comic books, it starts out by a car that looks pretty blocky by today's standards, but might have looked futuristic and modern back in 1941. And in various comic books, it goes through various incarnations. The ones that are at issue in the case, 1966, there was a licensed derivative work, a television series based on Batman with Adam West and Kurt Ward, for those of us who remember. And the 1966 version of the Batmobile was created by ABC, or at least created by people who were doing the work for hire for ABC. In 1989, we had the first Batman movie, directed by Tim Burton, with Michael Keaton as Batman, and that was licensed to Warner Brothers. And Warner Brothers creates the 1989 version of the Batmobile. How does Towle get sued? Because he is creating and selling replicas of the two vehicles and kits to modify existing cars. So if you want to drive your own Batmobile, Mr. Towle will be happy to sell it to you, or will be happy to sell you a kit that will turn your car into the Batmobile. So here's the 1966 version of the Batmobile. And here's the 1989 version of the Batmobile. What's the problem? The problem here is that DC Comics does not own the copyrights in these two things. Right? The television series, as a derivative work, the copyright is owned by ABC. Right? And we know for a derivative work that ABC can claim copyright in whatever was original to it. Right? So if they created the look of the 1966 Batmobile, to the extent it was original and not based on a real car, and to the extent it's separable from the useful article, because a car, after all, is a useful article. So if there are separable features here, ABC might own them. Same thing for here. Warner Brothers owns the copyright in the 1989 movie. They created the look of the Batmobile. To the extent there are separable features from the utilitarian aspects of our 1988 car, they should be owned by Warner Brothers. ABC and Warner Brothers are not plaintiffs in the case. The case is brought by DC Comics. DC Comics never drew or published a Batmobile that looked like this, or looked like this. Right? They drew different Batmobiles in the comic book versions of the books. So how does DC Comics really have standing to bring this case? DC Comics came up with a clever theory based on Ninth Circuit Kate law that the Batmobile is a copyrightable character. Just like Batman, just like Robin, just like the Joker, or the Riddler, or the Penguin, the Batmobile is a character. And so even though its appearance differs from version to version, we can protect our copyright in this character. And amazingly, the Ninth Circuit bought it. Right? They came up with a 3-part test for deciding what a copyrightable character is. It must have some physical as well as conceptual qualities. It must be sufficiently delineated to be recognizable and must display consistent, identifiable character traits and attributes from work to work, and must be especially distinctive or contain some unique elements of expression. I'm not sure I'd say that about the Batmobile, even if I'm applying that 3-part test. Right? The Batmobile is a prop. It's not a character. Now, are there cars that are characters? I can think of some cars that are characters. Kit in the Knight Rider, Christine in the Stephen comic novel. Cars that have a personality, right? And, it's much better, of course, if the cars can talk, right? But, if a car has a personality, then maybe it's a character. I don't think the Batmobile qualifies. I think the Batmobile is a prop. More fundamentally, this is simply the wrong plaintiff to be bringing this lawsuit. If ABC or Warner Brothers want to complain about somebody making replicas of the cars that they designed, I got no problem with that, as long as we can find some separable aesthetic features. But DC Comics shouldn't be able to complain about somebody making replicas of a derivative work to which they do not own the copyright. Ninth Circuit says otherwise. DC owns a copyrightable interest in the Batmobile character as depicted in the series and the movie, and therefore has standing to stop Towell from doing what he's doing. Okay. So, 5 more minutes? Okay, I can do these 2 more cases. The last 2 cases is going back a little further into 2015. A lot of you probably heard about this case, Garcia versus Google. This is Cindy Garcia. She is an erstwhile actress who was happy to get a job doing 1 day of filming for $500. She was told that she was filming an action-adventure story set in the desert to be titled Desert Warrior. Right? And she had 1 line in the film, and she shot her scene, got her $500, and went home. She was somewhat horrified later to find that her scene appears in an anti-Muslim propaganda video called The Innocence of Muslims. So the producers had allegedly defrauded her. Right? They told her she was going to be appearing in one thing, and instead they produced this 13-minute video about how horrible the Muslim religion is. And in her single scene, she appears on screen for only 5 seconds. They didn't even use her voice saying the lines that she had spoken when filming. Her voice was dubbed over with different lines, asking whether or not Muhammad is a child molester. Now, obviously, that is something that's very insulting to people of the Muslim religion. As you know, Muslims do not allow the Prophet to be depicted in any way, and certainly don't like pedophile slurs being used against him. This film was posted on YouTube. Didn't attract much notice for the first 3 months or so, until it was translated in Arabic and shown on Egyptian television, and suddenly there are riots in the Middle East. There are clerics calling for the death of everyone involved in the film, including Ms. Garcia. Now she's getting death threats against her, and she's very upset. And I don't blame her. Problem is, who should she be mad at? Right? It's the producer of the film who defrauded her. It's the producer of the film who dubbed over her lines and put her into this anti-Muslim propaganda video. You'd think she'd want to file an action against the producer. And indeed, she does so in state court. But what she really wants is this film to be taken offline. And so she's suing Google, who owns YouTube, and says, YouTube, you've got to take this film off of YouTube. Right? The district court says, no, we're not taking the film down. Goes to the Ninth Circuit, and the Ninth Circuit originally holds that her performance is a separate copyrightable work. See, her problem is, in order to get it taken down, she has to show that she owns a valid copyright. Well, she didn't create the movie, so she doesn't own a valid copyright in the movie. She could claim that she was a joint author, but joint authorship doesn't get her what she wants, because if she's a joint author, the other joint author could authorize it to be put on YouTube. So she has to find something of which she was the sole author. And she says, I was the sole author of my performance, and my 5-second performance is a separate copyrightable work, and you use my performance on YouTube without my permission, I can get it taken down. The Ninth Circuit panel initially agreed to her. On rehearing on bank, the Ninth Circuit holds 12 to 1 that this is not a separate copyrightable work of authorship. We're not going to take a movie and disassemble it into all of its component parts. That would make Swiss cheese of copyrights. They also said she didn't fix her own performance. It was fixed by the producer and the director. I actually disagree with this part because fixation simply requires that it be done by or under the authority of the author. She certainly gave them authority to fix her performance. So if her performance was a separate copyrightable work of which she was the author, I don't think fixation should be the barrier. The problem is that a performance is not separable. A performance is part of an audiovisual work that includes the scene design, the costumes, the lighting, the script, all of the other performances. Together, that's a work. Just as we don't say individual words and short phrases are copyrightable, we shouldn't say that 5-second performances are copyrightable. And the Ninth Circuit also holds she can't show irreparable injury. You'd think that death threats were irreparable harm. But the court says, yeah, but the death threats weren't due to your performance. The death threats were due to other factors. Copyright is not the right cause of action here if you're complaining about what's being done. And with that, I will leave that and we'll open it up for questions, I think.
Yes.
You want to sit down or stand?
Why don't you sit down? And first, for our online audience, I want to encourage you all out there to send in any questions you have. We have a chat feature here, and if you can send in the questions, I will read the questions, and Professor Ochoa can respond to them. Okay, so I don't see any questions popping up yet from the online people. So in the meantime, let me open it up to our audience here. Yes.
I have a question about Garcia Google. Do you know anything further about the contract? And if it's not a copyright issue, did she know in her contract? Does she know that the contract is going to include uploading to YouTube? And if it wasn't going to, did she sign did she go out to the contract for that?
Right. So for our
First, if you could repeat.
Yes, absolutely. So for our online audience, the question was about Garcia versus Google and whether or not her contract included a release that included YouTube. I don't know about the specific terms of the contract. It clearly allowed her performance to be used in a motion picture. I think that it would have included online uploading. Regardless, a cause of action for breach of contract is against the producer of the film, not against Google, right? The strategy that I think she could have pursued here, suing the producer of the film for breach of contract for fraud, right? If you get a judgment against the producer of the film, you can settle that judgment not for money, but by an assignment of the copyright. And if she then owns the copyright in the film, she would have standing to ask Google to take it down. Whether or not the producer would be willing to settle on those terms is a different question. It'd have to be a pretty significant judgment, but he's certainly not getting any money off of this other than minimal money from YouTube. So I would think that that would be a strategy she might pursue.
Well, let me read a question that came in online. This is going to put you on the spot.
Not a problem.
What is your prediction on the Supreme Court case? What is at stake here?
Well, I predict the Supreme Court case will affirm. As I said, I think whatever pattern is printed on the cheerleading uniforms is potentially separable from the design of the uniform itself. The design of the uniform itself is definitely a useful article, not subject to copyright, and neither party is contesting that. The question is whether or not the stripes, the chevrons, and the color blocks are separable. I think they are separable, and I think the Supreme Court will likely affirm on that basis. Whether or not there's sufficient originality there is a serious question. Because again, basic colors, primary colors can't be protected by copyright. stripes and chevrons can't be protected by copyright. Only an original selection and arrangement of those things could be protected. There's probably minimal creativity here, again, as long as it's not part of the way that the uniform is sewn together. What's really at stake, though, is a bunch of other cases involving useful articles. Are we going to be using the Sixth Circuit tests? Are we going to be using one of the tests advocated in one of the other circuits? What the Supreme Court says about how to decide these type of cases is going to be much more important than the ultimate result.
Do you think the Supreme Court will get into the question of, are these two common designs to be?
No,
created?
because the question of originality isn't before them.
Yeah.
The only question is, how do we decide what the design of a useful article is, or how do we decide what's separable from the design of a useful article? The Supreme Court likely will just say, we think this is the test. If they adopt the Sixth Circuit's test, they affirm. If they adopt some other test, they remand it back and tell the Sixth Circuit to reconsider under the new standard.
And just one more kind of follow-up. Do you think there's any notion of some kind of aesthetic functionality? Point 3, is it functional? Can the aesthetic look of something be functional?
I don't think the aesthetic look of something can be functional under the definition of a useful article in the statute. Because the definition of a useful article in the statute excludes things that are useful because they merely portray their own appearance. Right? And the whole point of that there is, looking at art is certainly useful in lots of ways we can think of, but art has to be copyrightable, right? So, they're trying to exclude things that are really utilitarian from the area of copyright, and aesthetic functionality fits comfortably within copyright protection.
Yes, Dean Corkery.
Yeah, with regard to the design of the uniform, these days, almost anything can be a piece of art. You could pick up a found object and hold it up and say it's a piece of art. And I'm wondering if uniform designs can be copyrighted, or why couldn't this particular design of the uniform be copyrighted?
So the design of the uniform itself, the question is, anything can be art today, even found objects can be art. Why couldn't we just say that the design of the useful article is art by itself? The question is not defining what art is, and the Supreme Court doesn't want to be in the business of defining what art is. The question is, what did Congress intend when it said that the design of a useful article was not protected by copyright? Right? And the reason Congress doesn't want the design of a useful article to be protected by copyright is so that other people can replicate that design. If you want the design to get an exclusive right in design, you're going to have to meet the higher standards of patent law. You're going to have to show not only that it's useful, but that it's novel and unobvious, and you're only going to get protection for a limited time. Copyright's very easy to get. They don't want utilitarian things to be protected for life plus 70, rather than the much shorter period of 20 years for a utility patent or 15 years for a design patent. Clothing has always been considered to be a useful article. The Copyright Office simply will not register a claim to the design of clothing, no matter how it, because it has to be cut and stitched together in particular ways. They will register fanciful costumes, such as the large head of a cartoon character, because that's separable from the clothing aspect of the useful article.
Yes.
On the Batmobile question, so if you treat it as a character, and then you say DC owns the character, if I understood the fact pattern right, ABC and Warner Brothers created those particular models. So, and those particular models were not used in DC publications. So, doesn't the result effectively strip ABC and Paramount of the unique aspects that they added to the character? So, the fins, the red lines, whatever, which were not DC products. And it seems like then now DC has control over those artistic elements that were added by other parties. It seems to be sort of an unjust enrichment thing.
So the question is about the Batmobile case, and if we treat the Batmobile as a copyrightable character, when ABC and Warner Brothers created the movie version incarnations of the Batmobile that were not themselves created or used by DC Comics, doesn't that give DC Comics the exclusive right over the look of the Batmobile, even against licensed versions from ABC and Warner Brothers? And I think it does, and I think that's the problem with the case, is that the reasoning of the case is so broad that it gives DC Comics over any version, any possible conceptual version of anything that could be called the Batmobile, regardless of who created the design. And if ABC wanted to go out and license people to create a Batmobile based on their version, they would have to get DC Comics permission. Now, depending on the contract between DC Comics and ABC to begin with, maybe that's not an unjust result, but it should be a contractual matter between those two. If the derivative work is going to be assigned back to DC Comics, fine. But that wasn't what the evidence showed. The evidence showed that ABC had created the derivative work. They should own the designs that are in the derivative work to the extent that they are original and different from the designs that were already in the comic books.
Let me ask one of the other online questions that has come in, and I was wondering about this myself, kind of focusing on the monopolistic element in the cheerleader case. Would you find the shapes to be too basic to afford a monopoly? Would the universe of combinations be too limited? In other words, if this is the leading cheerleader company, if they get too many chevron designs copyrighted, is that going to lead to a monopolistic situation?
Right. So the problem is not with any particular design, right? One design involving stripes and chevrons probably isn't infringed by a different design involving stripes and chevrons. It's pretty clear you shouldn't be able to protect stripes and chevrons and color blocks by themselves, right? You can protect a particular selection and arrangement. The problem is, though, if you then go and copyright 100 different designs involving stripes and chevrons and color blocks, you're basically trying to claim copyright over any combination of those things. And that could be considered to be a problem. In the First Circuit, you have a very broad view of the merger doctrine, which would probably prevent that from happening. The First Circuit says if there's really only a handful of ways of putting these things together, none of them should be protected by copyright, specifically to prevent that type of potential monopoly situation. Other circuits, though, follow a different standard, which says, well, there's only a few ways to do this. We're still going to give you copyright on your design, but it's going to be a very thin copyright. It's only going to protect your specific design. Even small variations probably wouldn't be covered by your design. That helps, but again, it doesn't solve the problem of what if one person tries to copyright 100 or 200 different designs involving all variations. Surely that would not be allowed to stand. We don't have the evidence in the case. We've passed the useful article part of the case, but we can still go back and decide there's not enough originality here, or it's too close to the idea for the merger doctrine to apply.
Yeah. Another online question raises an interesting question. Would a camouflage design on clothing be an example of aesthetic or functional? Put you on the spot again.
Well, that's interesting because some of the camouflage designs that were made for the Army have actually been the subject of design patents. A design patent being the ornamental design for a useful article. So they were at least able to convince the patent office that it was aesthetic rather than functional for purposes of a design patent. I think if you tried to register a camouflage design with the U.S. Copyright Office, they probably would not register it. They'd probably say that was functional. Yeah. But again, the Copyright Office is only your threshold. Yeah. You can still get into court, and the court would have the last word on that one.
Yes, Van.
I'm not sure which case it was. I think it was Hope Legends where you said that the Copyright Office refused to register for the last answer.
No, it was the yoga case where they refused to register the design. They did register the digital photograph of the hardwood floor.
Okay, so I stand corrected. Do any of these cases or the holdings of these cases filter down to the Copyright Office policy with regard to what they at some point will allow as subject matter?
Can you repeat
The question is whether or not the decisions in these cases filter down to Copyright Office policy. The Copyright Office policy is embodied in a very large manual, the Compendium of Copyright Office Practices. The most recent revision was done in December 2015 and just came out. And there's just a wealth of information in there as to what the Copyright Office does and does not consider copyrightable. They have their own views. They're allowed to intervene in a case if they've declined the registration and the court and the alleged copyright owner nonetheless claims that it should be registered or it should be original. The Copyright Office is allowed to intervene and defend its views. If there's controlling authority that says that something has to be registered, I think the Copyright Office will defer to that. But of course, only a Supreme Court decision would be controlling authority nationwide. A Court of Appeals decision would only be controlling in one circuit. I think the Copyright Office would feel free to continue to disagree until the Supreme Court had said otherwise.
We have time for one more question, and I'm going to read one that has come in online. I think you'll find this one interesting, given some of your writing in the past. Copyright in virtual property. Do you think that users of virtual worlds should have copyright interests in their virtual property purchases? How about rights in modifications of VP in V worlds? So if you can summarize your last article, that article into 2 minutes.
Yeah, this sounds like this question was planted
Maybe
somehow. I don't know.
I didn't do it.
Because I did write a very long and lengthy law review article on the issue of copyright in virtual worlds. And in that article, I took the position that some user-generated content should indeed be copyrightable. And I think the line should be drawn between a virtual world that might create a set of characters that you can choose from. You know, you can choose from these 12 characters or something. Well, those are things that they created. You're simply making a selection from one among 12. That's not really an original choice. It's highly constrained. That's not something in which you could claim rights. But where a virtual world provides a build engine that allows you to customize your character and allows you to create your own appearance, you know, then I think they're not really providing you with a constrained choice among things that they've already created. They're providing you with the tools for creating a copyrighted work. And so even though it says, well, you're selecting from among 12 different features for this feature, you're selecting from among 15 different choices for this feature, you're selecting from among 6 different choices for this feature. If there are enough features and enough choices, surely the game company cannot claim copyright in all of the features and all of the choices. You're the one who's selecting and arranging the various aspects that are provided of you. I think that's copyrightable, and you should have a copyright in that piece that you put together. Then that piece interacts with a virtual world that was created by others, so maybe that's a copyrightable contribution to a compilation or something along those lines.
Okay, thank you. For those questions that didn't get answered, we apologize, but we are out of time now. So let's give a nice round of applause to Professor Ochoa. Thank you very much. The last thing I want to mention is that, of course, those of you here live are eligible for CLE if you sign in and sign out properly. Unfortunately, we could not extend CLE to our online viewers, so we can't do that. But anyway, thank you, Professor Ochoa. It was an excellent presentation. And thank you for coming, and join us for our next event.